This is Attorney Clay Dawson of the Dawson Law Firm. Social Security disability, you've been denied, you requested reconsideration, you were not approved at that level, so you requested a hearing before a federal administrative law judge. And your attorney is telling you now that that's going to take you about 24 months before you get that hearing. That's a long time. Disabled people can't afford 24 months without help. They wouldn't be applying for disability if they could work and put a roof over their head, if they could put groceries on the table, if they could pay their power bill, if they could afford transportation. They wouldn't be doing it. They need help, and they don't need it 24 months from now. But that is the wait time. And as an attorney, we can try to get something done before then, but you have to understand that's usually what it's going to be, 24 months. Can you get an expedited hearing? If you're a veteran, there's a good chance of it. If you have dire need, you might get an expedited hearing. Now, frankly, what disabled person doesn't have dire need? But to Social Security, it means something else. When they say dire need, they mean like you're being evicted, your house is being foreclosed on, you're getting power cutoff notices, water cutoff notices, those sorts of things. Those can perhaps get you an expedited hearing, moving it up. I don't know, I can't tell you how far it's going to be moved up. Maybe you'll get one in 2 or 3 months. It's not going to be moved up to next week. So one way to get an expedited hearing would be through a dire need, or if you're a veteran and you meet certain criteria. Something else that we do during this level, awaiting a hearing, is once a judge has been assigned, we can request an on-the-record review, where if we believe we have enough evidence for the judge to make a favorable decision, we will request an on-the-record review. And usually we try to give a good summary of why the judge should do that, because basically we're asking the judge to go over a lot of evidence and make a decision. But if the judge will do this, if we have enough evidence and information, your application, your claim could be granted without a hearing, without having to wait 24 months. Now, that means that your case has to be ready, that you have to have that information and that evidence. So it's important not to wait until you get a notice of hearing before you start getting your medical records and your other stuff together. And if you watch the video on the Social Security disability hearing, you'll see there's not going to be a bunch of live testimony there. It's not going to be a parade of witnesses. That they're scheduling these hearings to last about 45 minutes each. So you really need to have your ducks in a row. You need to have all of your case prepared, and Social Security needs to have it on record ahead of time. Social Security is a form-oriented area of law. The forms that they make, the forms that they provide, are designed for your needs in your appeal, and they should be done correctly, properly, and they should be provided to Social Security well in advance of any hearing. Got to be ready. This is Attorney Clay Dawson of the Dawson Law Firm. Thank you for watching.